2.
Today's legislative update involves the relevance of one's criminal history in the licensure process. So over the past several years, we have seen a lot of legislation at the state level addressing this issue and seeking to remove that barrier to licensure. For example, some states provide an avenue by which individuals can seek pre-approval from a licensure board before beginning the application process, or even before enrolling in an educational program in furtherance of pursuing licensure in that profession. Many states actually prohibit regulatory boards from basing licensure denial decisions solely on one's criminal history, particularly where the underlying criminal conduct is deemed to be unrelated to the profession in which they're seeking a license. Earlier this summer, Connecticut enacted what is dubbed a clean slate bill. It requires the state to automatically erase criminal records in certain situations. So under this law, the state will automatically erase criminal records 7 years after a person's most recent conviction for a misdemeanor, or 10 years after their last conviction for certain low-level felonies. And these records include arrests, so it erases a record entirely, not just a conviction, but an arrest and all supplemental information and documents. What I find particularly interesting about this bill is Section 17, for those of you that want to wade through the 33 pages of the bill. What is provided as an example of a discriminatory practice as the state sees it under this law. So one example of a discriminatory practice is, and I'm quoting here, "For any association, board, or other organization, the principal purpose of which is the furtherance of the professional or occupational interests of its members, whose profession, trade, or occupation requires a state license, to refuse to accept a person as a member of such association, board, or organization solely on the basis of that person's erased criminal history record information." So I interpret this to mean that, by way of example, if you are seeking licensure as a private investigator, let's say, in Connecticut, and Connecticut requires that you be certified by a private sector certifying body as in order to become licensed, then that certifying organization may not deny you certification based on the erased criminal records, even if the organization thinks that it's entirely relevant to the profession. And the question I came away with is it constitutional for a state law to dictate the membership criteria for a private entity? Is it constitutional for the state to dictate whether or not a private entity bestows certification upon an individual? And I'm interested to see if this provision is challenged in state court and what the result might be. So stay tuned, and thanks for listening.